Amend this bill.
Mr Speaker.
The Honourable Phil Goff.
Mr Speaker, there are two parts to this bill, one of which will be supported by the opposition, the other thoroughly opposed. Part one does three things. First of all, it replaces the title of Senior Counsel with Queen's Counsel. That is an anachronism. It's not accurate, it's not relevant, and it's been dropped by most other countries. Secondly, it reimposes the restriction on where you can appoint senior counsel from. Previously, it was predominantly only from the bar, barrister's sole. It was broadened out to include those working in law practices and other fields of law, and this is a move backwards. And thirdly, it reverses the transparency of the appointment process. Now, for all three of those reasons, we are opposed to the bill, and I want to come back to them. Part two of the bill is largely concerned with practical measures, and I think they're reasonably sensible. They include a grandchild within the definition of relatives who are able to be shareholders in an incorporated law firm. They ensure that control of an incorporated law firm is maintained by the lawyers and conveyancers that work in it. Could well be. It provides a power of attorney becoming effective where a sole practitioner is an undischarged bankrupt, and it clarifies that applications for a review of a decision by the Standards Committee have to be within 30 days. All of those quite sensible moves, and that's the sort of legislation that we as a responsible opposition would support. But I want to go back to part one, because part one is unnecessary, it's a retrograde step, and there is no justification for moving in the way that the government is intending to do. Let's take the first one, and perhaps the least important of the three issues I mentioned before, which is, once upon a time, people who aspired to this title would be known as Queen's Counsel. We changed that. In fact, I changed that as Minister of Justice in drafting the law that was ultimately introduced and passed after I ceased to be Minister. And there were good reasons why we did it, and we did it after consultation with the Law Society. For a start, while the government says there is an historical link between Queen's Counsel and the past, that's true. In the 15th, the 16th and the 17th century, this was an accurate title. If you're a Queen's Counsel, you were there to do the King or Queen's bidding, depending on who was on the throne at the time. But that changed in the 18th century. And in the 18th century, people who took up that role, if I can use the words of the Bill's Digest, they ceased in any real sense to be counsel to the Crown and became simply a class of counsel who by eminence or favour had been given a rank superior to that of other ordinary barristers, end quote. That's the Bill's Digest. That sets it out absolutely accurately. These days, Queen's Counsel, or Senior Counsel as they became known, no longer operated for the Crown. They were not instructed by the Solicitor General or by Crown solicitors in most cases. They represented a wide range of clients, private individuals, private businesses. So the term Queen's Counsel ceased to be an accurate reflection of the sort of work that they did. Why would you want to go back to the term Queen's Counsel? In other mature Westminster-style democracies, in Australia all but one state, and in Canada, that title has been dropped and they are known as Senior Counsel. They are countries that are proud of their independence, proud of their sovereignty, and want to have titles and laws that reflect the 21st century, not the 16th century. This is a bit of snobbery on the part of the national government. That is the only reason for it. There is no justification given, no justification before the Select Committee, apart from a group of people with a self-interest in the bar that say, well, if it's restricted to us as barristers' sole, then we get the benefit of that title and we accrue the financial rewards from it. Of course they'd be in favour of that monopoly, but that is to suggest only people who are barristers sole have the ability and the excellence and the advocacy that would entitle them to carry such a title. So there is no argument, Mr. Speaker, in going back to a term, Queen's Counsel, that is about 3 centuries out of date. Secondly, Sir, the Bill moves to restrict appointments to the title of Senior Counsel or Queen's Counsel, as it might become, to people who are barristers sole. Well, the argument they make is that if you're a barrister sole, you are more likely to be independent. Mr. Speaker, when you examine what it actually means, you find that there is absolutely no justification for the government's position on that. Actually, the term Queen's Counsel suggests that you have a relationship with the Crown, which is the opposite of independence. But if you look at the commercial interests, again, there are strict rules governing all lawyers in terms of conflict of interest. They are bound by statute under the Lawyers and Conveyancers Act, Section 4B, to be independent. Restricting the appointment of somebody as a senior counsel because they're a barrister sole because they're more likely to be independent is a nonsense when every lawyer is bound by the statute, they're bound by the oath that they take, and they are bound by the Lawyers' Conduct and Client Care Rules 2008, requiring independence in the promotion of their clients' interests, requiring independence in terms of their professional responsibilities to the court. Jack Hodder made some comments to the Select Committee about that I think are particularly pertinent. He also makes the point that in the United Kingdom, where this law originated, in Canada and Australia, they all recruit senior counsel or Queen's Counsel from across the board in terms of people working for law firms or people who are barristers sole. He said, surely, if there was a problem with independence, it would have emerged in one of those jurisdictions. Has there been any problem in those other mature democracies? No, there's been no problems at all. This, again, is pure pretence by the national government. This is legislation put forward without an ounce of evidence to back it up. And that is no way to make legislation. Legislation should be evidence-based, and I searched the submissions, I searched the report of the Select Committee. There is no evidence to sustain the restriction of the position of senior counsel to people who are barristers sole. In fact, the law even contradicts itself because it makes an exception that perhaps you can appoint somebody from a law firm if they're an extraordinary individual. Well, if the Governor-General can appoint somebody who is not a barrister sole and that does not offend against independence, then that undermines the government's own rationale in bringing forward this bill that takes us back to the past. Mr. Speaker, the third section of the bill that I want to touch on is the selection process. And I've got to say that before 2006, the process of appointment as Queen's Counsel and now Senior Counsel was shrouded in secrecy. The Attorney-General had the responsibility. He or she could initiate that. They would consult with the Law Society or the Bar Association, but in essence, it was the Attorney-General making the decision, and that led to concern and suspicion about political patronage. And by God, wouldn't you worry about political patronage today, when even to the Broadcasting Authority, the New Zealand On Air, they're appointing the political chairman of the Prime Minister's electorate. In foreign affairs, they're taking away the professionals, they're appointing more and more people on a political ground, some of them obviously not up to the job, and I won't go into that, Mr. Speaker. But the fact of the matter, in 2006, we made the law more transparent, we made the process more transparent. There was a panel, the Solicitor General, 2 people from the Law Society, 2 people from the Bar Association. Everybody could see it. It was above board. That was the way to go. Mr. Speaker, I've got to say, in every respect, this is a backwards movement in our legislation. It's unnecessary, it's unjustified, it's wrong, and when Labor is re-elected, it will go.
Mr. Speaker.
Jackie Blue.
Thank you, Mr. Speaker. I'm very pleased